Giancarlo, welcome to Constituting America's Constitutional Chats. We're going
Thank
to
you so
ask
much.
we're going to ask you to make a few opening comments about today's topic of the Bill of Rights, and then we're going to go to questions.
Sure. I thought we'd open by I briefly tell sort of the story of how the Bill of Rights came about. And in telling that story, there's a recurring character who pops up constantly, and that is James Madison. And in telling the story of the Bill of Rights, you have to sort of pause for a moment and reflect on what it tells us about James Madison's statesmanship, because it's the story that emerges from this process is really quite remarkable as to the man himself. So it's early 1787. The government created by the Articles of the Confederation is too weak to be effective at much of anything. There's sort of a national panic gripping America at the time. It seems like this experiment is about to collapse. They are worried that the states will fragment and become prey to more powerful European nations. And just about everyone in America agrees that the Articles need to be at least amended, and some believe that they should be scrapped entirely and replaced with a new form of government. James Madison and George Washington are in this latter camp, and in late 1786, early 1787, they're sending letters back and forth between each other. And Madison is almost hot-headed about the prospect of a constitutional convention. He tells Washington, I've got a plan. We got to get this thing done. I've got a plan for how I'm going to get my plan done. Let's go. And Washington sends him these letters over, and he says, calm down. It's not time yet. It's not time yet. And finally, back and forth, George Washington finally, in his sort of infinite prudence, says, okay, now's the time. And so they've got this plan. Madison has a plan for a constitution, which comes to be called the Virginia Plan. And he says, okay, George, you're going to be president of the convention. I'm going to take the first stab at sort of setting the tone. Together, we're going to get my Virginia Plan passed. Things don't go to plan. Madison gets two early wins in the convention. First, the delegates coalesce around the idea that they need to replace and not amend the Articles of Confederation, and they agree that the new Constitution will divide power between three distinct branches, legislative, executive, and judicial. But beyond that, with respect to almost all the other smaller debates, Madison's on the losing side of almost every single debate in the convention. And now pause here for a moment and put yourself in Madison's shoes. You've been working on this plan of yours day and night for years. You're sure that it's going to save a country on the verge of collapse. You're sure you have put more thought into this than anyone else. You are sure that you are motivated only by selfless intentions, and yet you are losing every single fight. I would probably have been pretty frustrated. I might even have turned against the document that was eventually produced by the convention. This isn't the plan I wanted. I don't like it. You guys are being dumb. I oppose. There certainly were other men who did just that, but not Madison. As you probably know, Madison, along with John Jay and Alexander Hamilton, become the three chief defenders of the Constitution in the Federalist Papers. And one of the most effective lines of criticism to which they're responding is that the Constitution lacks a Bill of Rights. This, for example, is what motivates George Mason's objection to the Constitution. Why did they want a Bill of Rights? Well, having decided that the Articles of Confederation would be replaced with a constitution, a lot of the delegates to the convention naturally looked at existing state constitutions as guides, and many of them had bills of rights. Why? Well, because states had and still have what lawyers call the police power. That's a general power to do whatever is for the safety, health, welfare, and morals of the people. It's expansive, it's plenary, and prudence counsels that it ought to be restrained some way, that is, making sure it doesn't trample on fundamental rights. Now, many anti-federalists, those who opposed the Constitution, feared that the new government would be too powerful, and feared that without a Bill of Rights, it could trample on certain fundamental rights. So it's in Federalist 84 that our dynamic trio, in an article written by Hamilton, responds. And they've got three arguments against the Bill of Rights. Number one, the Constitution is a grant of limited powers. It includes no police power, so you don't need a Bill of Rights. The Constitution doesn't grant the government any power to deny rights. Second, including a Bill of Rights would create an interpretive problem. It makes it seem like the government has more power than it actually has. Because nothing in the Constitution, for example, gives Congress the power to restrain the freedom of speech, but if you include this, a line that says you can't restrict speech, well, doesn't that kind of imply that maybe somewhere in there is a power that would give it that authority? And then third, the Constitution already has a Bill of Rights. It protects the writ of habeas corpus. It prohibits ex post facto laws. It prohibits arbitrary imprisonment, bills of attainder. So you don't need a Bill of Rights. But again, Madison and the dynamic trio, they lose this fight. And what does Madison do? Well, true to his style, he doesn't sort of throw up his hands and say, I'm going home. the first Congress opens, and immediately it's Madison who proposes to introduce the Bill of Rights. And this is remarkable, not only because we know that he doesn't like the Bill of Rights, but also because several congressmen in this opening debate say, look, the federal government has just come into existence. We need time to figure out what we're doing. We should delay the Bill of Rights dispute until we get there. And Madison could have taken that opportunity to set aside the amendments, table them, maybe indefinitely, right? But instead, he pushes forward. No, he says there's a consensus that this should be done. Several states ratified upon this promise. We have a duty to do this. We've got to do it. And again, in true Madisonian style, he takes the pen, which is also remarkable. Again, remember, he doesn't really want to do this, but he takes the pen because he figures if I present the plan, I take the pen and draft them, I can keep this from going off the rails. I can avoid the interpretive problem. And so he ends up actually introducing, if you read in the congressional records what he introduces, it looks very similar. He mostly gets his way with respect to the substance of the amendments introduced, but he loses on two big points. First, he proposes to add a preamble to the Constitution that would incorporate actually the central premises of the Declaration of Independence in the Constitution so that the two documents sort of become one. And then second, he proposes that the amendments should not be added to the end of the Constitution as they are in like a separate document, but interpolated into the text. Why? So as to the first, he sees the Constitution as the instantiation of the Declaration. Just like Abraham Lincoln would say later on in sort of poetic style, the Constitution is a frame of silver around the Declaration's apple of gold. And as to the interpolation issue, Madison says, if the amendments are appended to the Constitution, it exacerbates the interpretive problem. Rights will take on a life of their own. The focus will be on rights, not on the limitation on the government's powers. So the government's powers will sort of eventually expand. And he argues that every time you amend the Constitution, you undermine its veneration. It's essential, he says, for national unity that the Constitution be whole, continuous, and integral in the minds of the American people. But as we know, he loses both those fights. But he remains, as always, a proponent of whatever the deliberative process produced. So two defining characteristics of his statesmanship, I think, are humility. Is almost astonishing willingness to accept other people's answers, and that they might be right and they might produce good, even though he disagrees with them. And of course, Madison has this supernatural ability to see the larger picture always and to subordinate his own interests to it. He saw that it was better to have a constitution that wasn't exactly what he wanted than to throw a fit over not getting what he wanted and maybe, get stuck with the articles or something even worse. And it was better to have a new nation that was unified than to oppose a Bill of Rights. And the rest is history.
Wow. I think that was the most energetic and engaging story of how the Bill of Rights came to be that I've ever heard.
What these men did in that time, right? It sort of feels dusty sometimes to us, but it was incredibly intense and fascinating, and fast paced, and it's really exciting to sort of study what these guys did and how they did it. It was,
Yeah.
fly by the seat of their pants operation. At no point did they ever have the luxury of like really sitting down and sort of ivory towering armchair this Constitution. They were building the plane as they were taking off, and what they created despite all of that was really astonishing.
Very, very true. So, Janine, would you like to go with the first round of questions, or do you want me to go to
Can you see me?
Yeah,
Yes.
Can you see?
yeah.
Okay, I can't see myself. I don't know why. So it's very bizarre, but I'm not on the Brady Bunch here, but as long as you can see me. Giancarlo, that was a wonderful introduction. And James Madison, John Adams would be so jealous of James Madison, consistent glory, and George Washington and Hamilton, and poor Adams is sort of like, what he chose.
Yeah, and maybe for other people, but Adams ranks real high up there for me. I think he's sort of one of the unsung heroes.
I do too. I really do, because he picked Washington, he picked Jefferson, he wanted the Declaration of Independence. But we need to get a statue for him in DC. That's just a goal for all of us. I really do. It's very exciting. We have our overarching aspect of the series is about millennials and the Z generation, and how they actually, how we have hope that the rising generations are actually clued in and appreciative and inspired by and want to promote the United States Constitution. So it's great to have you on the show. And I want to ask you about that in a little bit, but first I want to go back, to the Bill of Rights. One of the things, GianCarlo, I think is so interesting about the Bill of Rights was sort of the Connecticut Compromise that happened with it. And it wasn't the legitimate Connecticut Compromise, but it was two sides coming together to actually agree that they would be in existence. And we do a lot of Federalist paper studies and whatnot, but it was the Anti-Federalist, which we've talked about on the show before, but it's like Brutus and all of the Patrick Henry? No, Patrick, give me liberty or give me death. Patrick Henry, right?
Yep.
They were all the anti-federalist. And I think that the compromise, the fact that you talked about, James Madison did not want to do it. Hamilton didn't think it was necessary. And everybody was missing the point that if you have enumerated laws and powers, you don't need it. But they did it anyway. And I think, talk about that a little bit, the way it was that communication, it was dialectic, like Hegel, the philosopher, finding the spiral and rising. They were willing to do that. And I think that when we think about the Bill of Rights, we also really should be thanking the Anti-Federalist. What do you think about that?
No, I think that's exactly right. There was very much a spirit of iron sharpening iron in this. And, when you read the Federalist Papers and you read the Anti-Federalist Papers, what is astonishing to me, what's immediately astonishing to me as a writer in particular is that this is some of the greatest political thinking done anywhere in the Western world in the last 300 years. And it's done anonymously, not by professors of such and such, but by farmers. Like, it's astonishing to me. Nowhere in human history are you going to find a bunch of farmers who have thought so deeply about this and care so much, and not necessarily even because they have some sort of immediate personal interest, right? These are men who just deeply care that they're building something which is to the good of all of them. So yes, iron sharpening iron, this great debate between the both of them produces something which ultimately nobody is super happy with. I mean, well, that's not quite right. I'm being hyperbolic. I think everyone is actually pretty happy, particularly considering what they were facing. Right? The Articles of Confederation were a disaster. They were all imminently facing the prospect of being either reinvaded or sort of subjugated through political power to both France and England. Who were sort of circling the new American experiment like vultures, ready to sort of pick off weakness and sort of, take what they could get in the new world. So I think they're actually quite happy with what they get, but nobody gets exactly what they want. It's sort of the spirit of compromise. But they're all absolutely unified behind the idea that they are working towards the good of everybody and trying to produce something which is good for the people, right? And I don't use the people as sort of abstractly. I really mean the American people. They saw themselves as a people, a coherent people, and that these men who were in these positions of power, these brilliant farmers, were truly representatives of their next door neighbors, more so than really their own personal interests. It's really an astonishing time of intellectual development and certain moral virtue that was in such short supply. Well, pretty much everywhere else.
And we're doing a study on Alexis de Tocqueville, and he talks about indefinite perfectibility. I mean, continuing to perfect and perfect and perfect, and it's really an interesting concept that democracy gives us, and that also this ability to be free it gives us the opportunity to actually have opportunities in the arts and the sciences and literature and things of that nature, which we didn't have so much when we were all very industrious when everyone was starting out here in America. Because what he's talking about, he's saying in the essay that we're reading right now is 1840, will there be great thinkers here? But right now, but we still did. We had Benjamin Franklin and whatnot. But anywho, and the people that you're talking about, the brilliant founding fathers. The Bill of Rights, and I'm going to toss here in about 4 minutes. The Bill of Rights, the First Amendment, of course, I think is the greatest stance for the minority to stand against, to be able to oppose the majority. And then you go through some of the other Bill of Rights, and of course, they protect just our basic rights at court and things of that nature. And then at the very end, it gives the rights, 9 and 10, back to the people and back to the states, which represents federalism, which the states continue to have the power. So there really is sort of you could probably break it down into thirds about, the first third would potentially be, being able to have the minority stand up against the majority, the second being personal rights, and the third being states' rights. What are your thoughts about that?
So I also love the First Amendment in part for that reason. I actually think, though, having thought about this for several years, I actually had a sort of debate about this with a friend of mine some years ago. And he said, what's the most important amendment? And I said, I think the first. And he said, actually, it's the fifth. And over the years, I think he's actually pulled me around, and the reason being is that it's the protection, the due process protection against having your property confiscated, that actually guarantees the rest of them. And I think it's James Wilson who writes this in one of his many writings, maybe on his treatise in law, but he says it's the protection of the work of your hands. It's the property that you can produce, right? That guarantees all the other, because the government could say you absolutely free to speak your mind. But you know what, if you say that, I'm taking your house. Well, you're not really free to speak your mind, right? And you could say you can go to any church you want, but I don't like that church. That's now government property, right? So it's actually the protection, it's due process under law, which is actually the sort of stealth guarantee of all other rights. And I think he's probably right about that. As much as I love the First Amendment, I think he's probably right about that.
No, they were all great, weren't
That's
they? I mean,
true.
they all are really, really fundamental in the sort of encompassing our evolution as humans and liberty and having freedom in this country and being able to achieve and worship. They really were pretty brilliant. I'm actually glad they're there. And I thank Madison, as you were talking about, for being a man of his word, to say, no, we're going to do this. We promised. To think about it, they ratified the Constitution in the belief and the trust that this would be added later. I mean,
Right.
who does that anymore? Right.
Right.
It's like, okay, we're going to ratify it, but you have to give us the parade. And he's like, okay. So he was a man of his word to actually do that. And I think that's very vital. Right. Well, I'm trying to think if there's any other pertinent question I have about this. The I think I can toss, and I have 10 seconds anyway. So there we go. I'm going to toss to Tova next. And thank you, Giancarlo, for being on.
My pleasure.
Hi, thank you so much for being on. Like Janine said, that was a really great overview, and I love the
Thanks.
focus on an individual and his role in shaping the debate. It was interesting to me, the three criticisms from uh, from the Federalists defending against the Anti-Federalists
Yeah.
against a Bill of Rights. And I was curious which, if any, of the three original, criticisms or hesitations around the Bill of Rights, like you mentioned that there could be an interpretive problem, that the Constitution was already a minimal document, and that it, maybe already had a Bill of Rights embedded in it. Do you think any of those ended up having weight or playing out after the Bill of Rights was passed, or were they addressed through the debate?
Yeah, I actually am very sympathetic, even to this day, to the interpretive problem. That just for a reminder, and that's again that if you make a Bill of Rights, and especially if you attach it to the end of the Constitution, you stop focusing on when a dispute comes up. The question is no longer, does the federal government have this power? It's, do I have this right? And I'm actually very sympathetic to the argument that, well, when you've adopted that framework, you actually have sort of lost sight of what the Constitution is really trying to do. And, you sort of look around today and you see a federal government that is immensely powerful, that wields something very much like the police power that the states have, which is way beyond the comprehension of the founders. And you sort of wonder, is that partly partly caused by what we did with the Bill of Rights? Have we sort of lost focus of the government being of limited powers and focused instead on, well, you have whatever power you want, just don't deny me my rights. There may be, it's a complicated question to answer from a cause, examining causation. The reason is, I know, and I think I think I'll stipulate that it's probably part of the problem, right? Even Alexis de Tocqueville, writes about this. He says, this sort of focus on rights has, I don't quite remember how he frames it, but essentially a corrupting effect on the body politic in a democracy. But that being said, in Madison's defense, I don't think the founders ever could have anticipated the modern progressive development of the 1900s and through the 1920s. Woodrow Wilson style progressivism, where there was a real powerful academic movement that said this whole separation of power stuff is nonsense. What matters is giving somebody all the power that they need to deal with the exigencies. And that, I think, you couple that with a Bill of Rights interpretive problem, and you get a modern administrative state that does whatever it wants, subject only sort of to whatever constraints a court can put on it after the fact. But remember, too, that particularly the Bill of Rights interpretive problem has made us sort of think about rights in the context of courts, right? The courts are going to protect free speech, but Congress also ought to be doing it on the front end, right? Every court victory for free speech is still a rearguard action. It means that somebody lost in Congress. They lost in the executive. They lost in the legislative branch. And when you have a situation where the federal government is presumed under sort of modern progressivism to have all the power it wants, and that the only constraint is your right, legislatures wield all the power they want, and it's sort of left for courts to pick up the pieces. But if we're only picking up the pieces after the fact in court, that means that a lot of those fundamental rights are not being protected. So yeah, I find the interpretive problem criticism pretty strong, actually. But I don't know. Again, I don't know that it was wrong at the time to do it. I actually still don't really know if it was wrong now, because like Janine said, those rights do protect us in a big way. Especially from a sort of all-encompassing government. So it's a real tough question, but that's a long answer to your short question.
No, that's fascinating. And yeah, you're right. I like that distinction between, was it wrong at the time, or like what is the impact today? Because you're right, the country has changed in such in massive ways, and it's always significant to me that we have the shortest and the oldest constitution. Like that is very significant. So my second question is about how states influenced the Bill of Rights. So sort of twofold. One, I was reading recently about how state constitutions and state bills of rights actually, influenced the Bill of Rights.
Yes.
For instance, like the Virginia Declaration of Rights and the Massachusetts Constitution. So could you talk about the interplay of how the Bill of Rights could have taken provisions or inspiration from state constitutions? And then also if there was any debate between states, or if debates around the Bill of Rights broke down along geographic lines?
Actually, that question is interesting. The second one, I confess, I don't know the answer to that one, whether the debate over the Bill of Rights broke down over geographic lines. I know that there were some states which didn't particularly care for one or for against one, and some states that really cared, like Virginia. Sorry, remind me your first question. Oh, the interplay between yes. So state constitutions and their bills of rights really were the model. The fact that they existed in state constitutions is what gave the impetus to the movement to get one into the Constitution. Many of the protections we have in the Constitution are pulled directly from different state constitutions. But actually, so one interesting proposal that Madison initially included, which was present in many state bills of rights, or many state constitutions, and not ended up being adopted, was what we would today call a non-delegation clause. And so many state constitutions said that the legislative power is vested in the state Congress, and it cannot be given to any other branch, same as, for the state executive and state judiciary. Madison said, that's a good idea. Why don't we'll keep that in our Bill of Rights. And it didn't get passed during that first Congress. And the reason it didn't get passed is really interesting, given where we are today, is that everybody thought, oh, that's assumed. You don't need to put that in. That's sort of encapsulated in, Clause 1 of Article 1 and Clause 1 of Article 2, right? But, of course, today we have an immense amount of delegation among the branches. So yeah, interesting to see which ones made it through and which ones didn't and why. Like that one, everyone sort of assumed it was present, although, many people would probably wish that they hadn't assumed quite so broadly.
It's really interesting. My final question I had was why delegates decided, this is going back to the beginning of your remarks, why did delegates decide ultimately that they needed to replace and not just amend the Articles of Confederation?
Yes. So there was a consensus sort of, well, everyone agreed that the articles had to go or had to be changed. And when they began this process of looking at the problems that the articles either created or were allowing or didn't provide a remedy for, they realized that the changes that would be needed were like immense. Like you really were going to have to, like, you could call it Articles 2.0, but you really were going to have to like rebuild this from the ground up. And the reason why a lot of people sort of felt uncomfortable doing that is because, well, the Articles of Confederation say if you're going to amend them, you need all the states on big questions. You need unanimity. And do we have unanimity to like torch this document and create a new one or like totally gut it? Like it's kind of a weird, like, do we have this power? Do we not kind of question? And actually, if you might remember, it's in Federalist 40 that Madison actually writes his response to this concern. He says, look, the articles were intended to create an adequate government, but they failed. So you couldn't sacrifice the article's ends to preserve the article's means, right? If the means weren't delivering, you gotta replace it to advance the ends. And he says a little tongue in cheek, I think, yeah, the Constitution actually only expands the principles of the articles, he says in Federalist 40. But of course, a little bit later on in Federalist 40, he says, but yes, this entirely transforms the articles. But essentially it was, this is just if we're going to save this country and keep it together, this just has to happen.
Well, I don't have enough time to ask another question, but that was really great. And I think it just speaks to the incredible way that the founders were able to create a process that was both responsive and able to adjust when there were very deep flaws, but also one that could endure for so long. And I think that speaks to all you were saying about the level of statesmanship and commitment and brilliance that they had. So with that, I'll pass on. Thank you.
Hello, this is Kenyamwana speaking, and thank you for being here today. This is a
My
really
pleasure.
good talk. So my first question for you is, I know you talked a little bit about this earlier, about some of the amendments that were not ratified, but could you talk a little more about some of the amendments that weren't ratified and why?
Yes. So let me tell you about my favorite amendment. It's not actually, it's objectively not the best amendment, but it's the amendment with the greatest backstory to it. This is the 27th Amendment. And slight personal plug, I am technically, by dint of default, the nation's leading expert in the meaning of the 27th Amendment. And the reason why is because I'm the only person who's ever written a law review article about what it means. But it's the 27th Amendment. The 27th Amendment says, no law varying the compensation of members of Congress shall take effect until an election of the House shall have intervened. Basically, Congress can't change their own salaries until an election has happened, because if they jack up their salaries, the American people should get to, express their thoughts about how Congress is paying themselves. Well, the 27th Amendment was actually introduced in Madison's speech, where he lists his amendments, and it's number 2. This comes back to Tova's point. There were 3 states that proposed this amendment: North Carolina, think Virginia was one, and I forget the other. But it doesn't end up getting through. They just sort of decide, the Bill of Rights should really be about rights. And so like apportionment was one of the other amendments. That was amendment number 1. Not going to deal with that here. Salaries for representatives, we're not going to deal with that here. But so nothing happens to it. Fast forward to the 1980s, and this kid in college in Texas is writing a paper for some class on constitutional law about how to amend the Constitution. And he proposes this theory. He says, well, technically, what we call the compensation amendment is still a live issue because there was no deadline for it to expire. So Congress could still amend the Constitution, grab James Madison's number 2 from 1788, grab it, pull it back into the modern day. He gets a C- on the paper. His professor doesn't buy it. He says, no, this it's dead. And in spectacular spirit of fighting for his grade, he launches a solo campaign to get this ratified. And in 1992, he gets enough states to ratify it, becomes the 27th Amendment. And, when he's 35, he goes back to his school and says, I would like you to change my grade. And they do. They give him an A in the class 20 years later. But that is my favorite story from the amendments, the ones that didn't make it in, but did eventually. But also, so there was the non-delegation one, which I mentioned when I was talking to Tova, that didn't make it. And then number 1 was going to be how you apportion representation among the states. That was number 1, also didn't make it in that one.
Yeah, that's really funny, the story about how that got ratified.
You just gotta love
27
his chutzpah,
Yeah, it's really funny. Another one is that there's been some dispute over some of the over some of the rights we were given in the Bill of Rights today, like dispute over how far they should extend and stuff like that. So I'd like to ask you about what the founders might say about dispute over some of them today.
Yes. So they would say, I think, that the whole way that we think about modern debates over rights today is wrong. The question for them would never have been how far does your right go? Because what you're asking is, how far does your right go against what? Against government power, right? And that's immediately the wrong paradigm. They would say the question is always, what's the government power that's been given? How far does it go? And then wherever it stops, it stops. And the realm beyond where government power stops is the realm of rights. So yeah, they would definitely have taken a very different view. They would also have rejected the idea, which is so commonplace now, which is that the courts are the protectors of rights. The courts actually for them were not to be the primary protector of rights. The legislatures were supposed to be deeply cognizant of people's rights and to take that into account in the first instance. And that if Congress was focused always on, do I have the power to do this? Then you wouldn't worry about protecting or infringing on somebody's rights, because the powers granted were to be so constrained that you left tons of room for sort of just right and lawful expression of rights. So I think that's what they would say. They would be sort of at a loss about what we've done by inverting that paradigm, to sort of default to the position that the government has all the power it wants, except these little areas of rights that we've carved out. That's got it backwards.
Makes a lot of sense that the government should think about its own powers that it has instead of just rights. And you touched briefly on saying that there was a Bill of Rights sort of embedded in the Constitution, like certain rights in there. Can you talk on those for just a second?
Yeah. So what you might have noticed actually is the Bill of the rights that Hamilton mentions as being in the Constitution, ex post facto laws, right? Habeas corpus is protected, no bills of attainder, right? What stands out about those rights immediately is that those aren't natural rights, right? Those aren't freedom of speech, the freedom to own the property that you create, right? It's not natural rights. Those are all the traditional rights of Englishmen under the English constitutional tradition. And there's a reason that Hamilton doesn't want to say there are natural rights in the Constitution. It's not because he doesn't believe in them. He certainly does. It's because he's concerned that if you articulate natural rights in a Bill of Rights, it gives two false impressions: either that those are the only natural rights that exist, which of course is not true, or that those are the only natural rights that can be protected against government intrusion. Also not true, right? That's why we have the Ninth Amendment and the 10th Amendment, which tries to carve out space for other ones not enumerated. So if you were concerned, as many anti-federalists were, about natural rights, I could actually see that argument of Hamilton's doesn't persuade you, because you would know immediately, as American colonial coming out of the British constitutional history, you would know that those are the rights of Englishmen, and what you are concerned about are natural rights, which are a separate category.
Yeah, that's really interesting. Makes a lot of sense, that distinction there. And then last thing is what are some amendments that were passed after 1791 that might constitute some rights that were not spelled out there?
Oh yeah, sure. Well, of course, the 14th Amendment is the elephant in that room, right? Basically extends many of the Fifth Amendment protections and citizenship to all Americans, right? The purpose being to predominantly to give Black people who had been slaves the full rights of citizenships, which had been denied them both by slavery and Dred Scott, of course, right? But that also then applied a lot of protections from the Bill of Rights, which had been against the federal government, to the state government, right? There's a quote by, who was it? Senator, oh, I forget. He was a senator during Reconstruction who was a German immigrant. I forget his name. I'll find it for you later. But he was a German immigrant, and he said basically the Constitution had been concerned with protecting the rights of people against the federal government. The Reconstruction amendments are concerned about protecting the rights of the people against state governments, right? So the 14th Amendment really flips the Bill of Rights so that it affects both the federal government now and covers the states as well, because it was the southern states which were so notorious for violating the rights of Black citizens, Black Americans, slave and freemen. So that's the one. And in many years of Supreme Court jurisprudence since the passage of the 14th Amendment, the Supreme Court has said the 14th Amendment, the legal term is incorporates. It incorporates certain provisions of the Bill of Rights against the state. So, you read the 14th Amendment, and it doesn't say it protects your right of free speech against your state government, but the Supreme Court has interpreted it as doing so. So the 14th Amendment grabs the first, pulls it in against the state. So that the 14th Amendment is by far the most important amendment with respect to expanding the reach of the Bill of Rights to state governments as well.
Yeah, thank you very much for that. I think it's pretty important that gets expanded to all levels of government as well, not just the federal. Anyway, it looks like I'm out of time, so thank you so much for answering my questions, and I'll pass on to Kathy for some audience questions.
My pleasure.
Well, thank you, Kenyon, and thank you, Tova, and thank you, Janine and GianCarlo. You're just such a great guest, and
I appreciate it.
So engaged. We've got a lot of questions. First, we're going to give a quick shout out to a teacher and classroom that is watching today. Matthew Barnes is watching with the Emerald Coast Christian Academy. So welcome, Matthew, and your students for being on with us today. We also want to thank our listeners in Las Vegas's KKVV 1060 AM. KKVV airs these Constituting America live Constitutional Chats podcasts on Mondays at 6 p.m. Pacific time. So thank you to everyone in Las Vegas listening. So GianCarlo, first of all, we have got a question here from Robert McKeeman, who asks, in Amendment number 8, who determines what is cruel and unusual punishment?
Yes, great question. So today, of course, it's the Supreme Court that does it. Back then, cruel and unusual punishment actually had a pretty established definition. That's not a vague, to our ears today, that kind of sounds like just a vague term. It means whatever you think it means. But actually, that was a term of legal art, and it traces its origin to the English Bill of Civil Rights, I think of 1692. Don't quote me on that, but it's the English Bill of Civil Rights of late 1600s. What was happening at that time is you had the Stuart monarchs. These are Catholic monarchs. They came along, and there was a lot of religious tension and a lot of religious persecution when the throne would switch back from Protestant to Catholic and Protestant to Catholic. And there was a Chief Justice named Lord Chief Justice Jeffreys of the English Supreme Court. And what he did, now that I mention it, now that I say it out loud, I forget whether he was Protestant or Catholic, but it doesn't really matter. He was on one side and really hated people on the other side. And so there was a case in which a clergyman was convicted of perjury. Now, he was a clergyman on the other side. He was either Catholic or Protestant, and the Chief Justice was Protestant or Catholic. And perjury was an offense in England which was punishable probably by jail time, but certainly not punishable by death, right? It was not the sort of offense for which really serious punishment could be imposed under law. But Lord Chief Justice Jeffreys said, well, I can't sentence him to death, but I don't like him because he's a clergyman of the other side. So what I'm going to sentence him to is like a year in the stocks, where he has to sit outside every day, all day, for like a year in winter and in heat, and people can throw rocks at him. I mean, it was functionally a death sentence, right? Everyone, like if you were sent to the stocks for a year, you're going to die. But it wasn't actually a death sentence, right? So it was technically not, but then the English Bill of Civil Rights said that's ridiculous. It's cruel and unusual punishment. Why? Because it's punishment for which is not permissible under law. So that's really the answer, right? The legislatures of the various states, and to the extent that we're dealing with federal crimes, Congress gets to set crimes and punishments. Then no judge may come along and say, you know what, I'm going to get real creative here and give you a real nasty sentence, which I can't technically do, but I think I found a loophole, right? That's who was supposed to be deciding those sorts of questions.
Well, thank you. And one of our listeners, Lewis White, is lamenting what he calls the death of the Bill of Rights. And he gives a list of a lot of violations of the Bill of Rights. And he's just wondering, if you might have some comments on that. And some of the things that he lists are judicial rulings to include those from the Supreme Court that have allowed loopholes to violate our rights, such as people not being free to worship during COVID-19, or infringements on the right to keep and bear arms, or no double jeopardy, no self-incrimination, which he cites are forced blood test and DNA swabs. Just a whole list here. What do you think? Has the Bill of Rights trampled on?
Well, I think that this goes back to the point I was talking about earlier about the way we've shifted our paradigm away from government power. And if your default position is that the government has all the power it wants, the realm of your rights is naturally going to shrink anytime the federal government comes along and says there's an emergency. So the government has the power to respond to any emergency however it sees fit. That is always going to push against rights, right? Like the church closures are an excellent example. When we hear a church has been closed because of COVID-19, what we think about is what is say a Christian or Jews or Muslims, what's the nature of their religious right to free exercise in person versus at home in private, right? That's the wrong question, is what the framers would say. They would say, what gave the federal government the power to do that in the first place? I don't have a good answer to that question. Frankly, what gave the federal government the power to shut down a church? I don't have a good answer to that. I cannot point you to a provision in the Constitution that explicitly or even by implication gives the federal government that power. But we stopped thinking about it that way. We started thinking about it in terms of rights, but rights are always going to be pressed in by the federal, by governmental power. Every government act is a denial of perfect freedom right now. That's not to say that government acts are bad. There are many reasons why freedom, perfect license, let's call it license, ought to be limited. Like I technically have, in this sort of state of nature, the license to punch you in the face. That's the sort of thing that the government ought to be preventing me from doing. But to have thought about rights as the starting point and not power means that as the government continually presses, rights are in the position of pushing out rather than just existing in a much larger zone where the government doesn't have the power to operate.
Well, thank you. And then Robert Zimmerman, one of our great supporters of Constituting America, asks, he says, may be covered as signed in late, but with intent of Bill of Rights and the 14th Amendment, can the birthship rights for citizenship be limited by the courts in a way that follows the amendment author's original intent for these rights?
So
And
yeah, this is a
thanks and impressive knowledge and conversation by GianCarlo.
Oh, my pleasure. Thank you. So let me confess I don't have the bit of knowledge which is required to give you a direct answer to your question, but let me tell you how I would think about it. So the line in the Constitution, right, is that anyone born here and subject to the jurisdiction thereof is a citizen, right? It's not just born here, it's subject to the jurisdiction thereof. The question is, what does that mean? There is an answer, there's a historical answer that meant something to the people who ratified that amendment. I don't know what that is, so that's why I can't give you the full answer. But I know that there are sort of two theories. One theory, the sort of permissive theory, is that just if you're born here and like the government has the power to arrest you, so you're not a diplomat, right? You're subject to the jurisdiction thereof. There's another school though, which actually one of my coworkers here, Amy Swearer, is one of the leading scholars on this. So I should have studied her paper in more detail, so I apologize. But the other theory is that actually subject to the jurisdiction thereof means more than just like the police could arrest you if you commit a crime. It means that you are reliably loyal to America. You don't have competing loyalties. So that the implications of that argument, I think, are that you can't be be another citizen. It probably means that like your parents can't be the sort of like birth tourists that we see. We get a lot of people from China, right? They know they're pregnant, they come here, they give birth so that their child is a citizen, and they immediately leave, right? Called birth tourism. Those people probably wouldn't be citizens under the restrictive understanding of subject to the jurisdiction thereof. But your question really turns on what's the definition of that line and what does it mean? And if my colleague Amy Swearer is right that the restrictive definition is correct, then yes, a court would be able, given an adequate case and controversy, would be able to say, no, you're not actually a citizen because although you were born here, you were not subject to the jurisdiction thereof.
Well, thank you. And Paul Pierce says, just need to say this is the most astonishingly clear description of the creation of the Bill of Rights. And Terrence Durbin says, enlightening discussion. And I want to be sure and come back to Janine here at the end. But Terrence Durbin also asked about the picture on the wall. If you could just tell us quickly, right?
Yes. So that is one of my favorite people in American history. That's Frederick Douglass. A friend of mine who's a Black conservative wrote a magazine article. I forget what it's called, but it's a magazine geared for Black conservatives. And he wrote an article about Frederick Douglass. And this was the image that the magazine printed over the article. And I was so sort of blown away by it. It's loud, right? It's not black. It's vivid. It's loud. It's sort of, Frederick Douglass made relevant to the modern day, and I just loved it. So I found the artist and ordered a print. So that's that.
That's great. Well, thank you. Well, Janine, I want to come back to you. And you're muted.
Okay. I was gonna say it looks like a Leonard Nimoy. He did that kind of art. And well, you were talking about, and thank you again, Giancarlo. It has been an exceptional show. You're talking about natural rights, and I guess one of the things that we talk about in regard to national rights is what we always talk about in the schools, which is what it says in the Declaration of Independence. That we are given these rights by our Creator. We hold these truths to be self-evident that all men are created equal, that they are endowed by their Creator with certain unalienable rights. And I can understand the wonderful argument you put forth about why they didn't want to bring that in, but it seems, if you compare and contrast that to the question we had from a listener just a minute ago, that in this day and age, that would be a great argument. Not a great argument. Well, a great argument based on people understanding the truth which is our First Amendment rights, we are given those rights by God. And there just seems to be so much confusion about the government gives us those rights, or that the Supreme Court can take them away, or the legislators can take them away. So that is the one instance, you know, where I think that natural rights might have been interesting to say there, even though I know they didn't, but it was certainly is time in this environment for people, because you hear that discussion all the time. The government might do this and the government might do that. Well, the government doesn't have the right because we're born with them. And that was a fundamental principle of everything that they wrote in the Declaration, you know, and the Constitution. It was really was based on natural rights and the
You know,
so
that's exactly right. I mean, you know, there's that famous line from the Federalist Papers: "If men were angels, no government would be necessary." What that recognizes is that you have to govern people according to their human nature, right? That is, we are reasonable, we are endowed with reason, but we're fallen, right? We're fallible. You can't govern people with this idea that like you can make them perfect, right? That's not happening. You can't govern people with the idea that like if you just put in all the right people in the right positions, they got the right power, we're going to create a utopia. That's just not how things are. We've got a human nature. It's fixed. It's knowable. This is the founders, this is their baseline, right? We've got a human nature. It stems both from God. Well, it stems from God, and as sort of determined by the world that he's created. And that you have to govern people in accordance with their nature, and their nature implies certain rights, right? But we've forgotten that. Like not that long ago, there was a reporter, a very high-profile political reporter, I think either for Politico or CNN. Quick Google search will find this, but she really stepped in it because she made fun of somebody for saying that, you know, we've got rights endowed by God. And she just sort of totally forgot that the Declaration says that. This is not some like right-wing crazy.
Or she didn't know.
That's right. She didn't know. She didn't know.
But they can't teach that in school these days because they can't talk about God, right? It's like, oh, we can't talk about God, so they don't know. And I remember that reporter, and she really did. But so many people, if you were to ask them, wouldn't even probably understand that those rights do not come from the government.
Right. And to the question that one of the listeners, you know, brought in, if you think, if your standpoint is the government can do whatever it wants without trampling on my rights, and then you add to that the premise, and rights come from government, well, that's the end of rights. That's the end of rights. And the founders were really aware of this. Why? Because under the British parliamentary system, the British constitutional system that they were evading, rights did come from Parliament. Parliament was supreme over the king. You had rights against the king. You had what rights Parliament gave you. But Blackstone, he's the sort of the great British commentator on law, right? Blackstone says Parliament's supreme over the Constitution. That means Parliament's supreme over your rights. And the founders here were like, no. Our rights come from God. They're inherent in our nature. You don't get like those exist whether you like it or not, and the government can't do anything about it.
Mm-hmm. Yeah, it's really thought provoking. So thanks for letting us do that. And I'll toss back to Kathy. And I will just say for everyone who's interested in, you know, young millennials and Z generations, you give everybody hope. as does Kenyon and Jewel and Jorn and Tova and everybody. But thanks so much. Appreciate it.
Oh, my pleasure.
Kathy, I'll toss back to you.
Yeah, thank you so much, GianCarlo. And we want to wish all of our listeners a very Merry Christmas, Happy Hanukkah, Happy Holiday Season, Happy New Year. And we are going to be off the air for 2 weeks, and we're back on January 7th. And we've got a very special guest coming on January 7th, Mary Catherine Ham. So we hope everybody will join us back. And GianCarlo, how do we listen to your podcast, the SCOTUS 101?
I forgot to mention that actually SCOTUS 101 is no more. We've handed the reins off to one of our colleagues, Sarah Parshall Perry, who has her own podcast now called Case in Point.
Okay, great. Well, we will be on the lookout for Case in Point then. And thank you for the great work that you do with the Heritage Foundation. And thank you so much for being on today. And
my pleasure.
To all the audience.
Yep. And Chris Foster's out there. Hello, Chris Foster. Is he there? We started with you, Chris Foster, one of our first board members. And thanks to all of our donors that make this possible. Oh, and you could go donate monthly, $17.76, $17.76. So check that out too. All right. Merry Christmas. Happy New
Merry Christmas.
Year.
Take
Happy
care.
holidays.